welcome to the 275th session of Legal Empowerment Through Interaction Lecture Series. It has been a wonderful journey and it's a momentous occasion. And to celebrate this occasion, we have a wonderful speaker, a good friend and a well-wisher of this platform. And I'd call him as my elder brother also, because the way in which the last session was received and the kind of response it had was wonderful, and an extension of the same thing, that subject, but the latest developments and nuances and what all have happened after the RERA has come into force is the topic today, a critique on the Real Estate Regulatory Authority, the Act. And all of us are very interested because there has been recent decisions which says that Consumer Protection Act and RERA will they coexist. The Supreme Court has clarified that. And whether in corporate insolvency resolution process, whether a apartment purchaser is a corporate financial or not, all those things, there's a lot of changes that has come around, and today we'll be exposed to the latest, the very latest in happenings in the specialized and this wonderful topic. Today we are privileged with the presence of Justice Ramkumar sir, Justice Ramakrishnan sir, and all of you wonderful participants who have been part and parcel of this journey of empowerment, discovery, discussions, and without wasting any time, may I request Justice B. Rajendran sir to address us on the topic of today. Thank you very much, sir.
Very good evening to one and all of you. My good friends Shyam, Justice Ramkumar, Justice, they're all here with me. Thank you for coming, first of all. And let me congratulate the organizers for one thing. Conducting 275th meeting, really it is wonderful. It started during the Corona period and the momentum was not let out so easily. It continues that, and I happens to earlier meet all of you at the 199th meeting and now at the 275th meeting. I, as a secretary, know the difficulties of organizing one meeting. Here is a person, with the help of all of you, had conducted 275 meetings continuously without any hitch. Let us all congratulate him on this tremendous, stupendous task, and kudos to him for this. And I must thank every one of you that I have become a part of this and being in there in the 275th one. Thank you so much for giving this opportunity. And once again, thank you everyone for having participated on this. Let me start with this, because when we discussed with Shyam, he said, he has used the word, beautiful word. He said, RERA, a critique. I was wondering whether he wants to be criticize the act. Then he said, no, as for the dictionary meaning, it's an overall view and of the subject. I also went in deep into that. Why did he call this as a critique? When this says, when it goes into a deep into a subject, first you see is how it is developed. This is the main thing we come across. Now, the act came in 2017, 1/5/2017. It was promulgated. Actually, though the act says it's the act of 2016, some of the provisions were not incorporated. Those provisions, main provisions, were incorporated only on 1/5/2017. Therefore, literally, it started on 1/5/2017. Now we have got 5 years past. And I've been a real estate appellate tribunal chairman for the past 5 years in that, and recently retired. I've seen the development. Number one, the main development was and is, originally, people all were afraid, namely the builders were very much afraid to come to RERA. They were under the impression RERA is against them. People all thought it was only an act only for the benefit of the consumer. At the same time, they also stated that this is going to affect the profession. Let me bring one particular passage from the object, which has been called out by the Supreme Court in the latest judgment in a different way. This is in the New Tech judgment. It's called the New Tech Promoters and Developers Private Limited versus State of UP. In paragraph 10, It was introduced with an object to ensure greater accountability to its consumers, to significantly reduce frauds and delays, and also the current high transaction costs, and to balance the interest, this is the word used by Supreme Court, balance the interest of consumers and promoters by imposing certain responsibilities on both. It's not on one side, on both. And to bring transparency of the contractual conditions, set minimum standards of accountability, and the fast track dispute resolution mechanism. It also proposes to induct professionalism and standardization in this sector, thus paving the way for accelerated growth and investment in the long run. Though it is the object set by the Supreme Court, enunciated correctly, it is an obligation on both. I'll come at a later stage how the obligation is to be done by both. Now, when I took over in 2017, the first condition, number one in the registration in the RERA is every project has got to be registered. Now I have retired, therefore I can stop. Well, there was a clause. If you find, I was the one person who was asked to draft the regulations. The moment, because I was the first person who took over. I got the rules of the entire country. At that point of time, only 12 states, the act was promulgated, where they have implemented, I would say implemented. Act was promulgated for the country, but implemented only in 12 states. Every state has a rules frame. If you see the rule, the act says every project has got to be registered. There's only two classes. Number one, if it is less than 500 square meters, it will not be registered. If it is less than 8 flats, it will not be registered. All other flats have got to be registered. It also stated, the Act clearly stated that even if it is an ongoing project, say for that moment, it had used the word when the completion certificate is not obtained, or the occupancy certificate is not given, or the pending project which is ongoing on the date of implementation of the Act, then also it has got to be registered. But when I read the rules of different states, including in Tamil Nadu, there's rule 2B says, if the structure is completed, the word used structure is completed by erection of the beams and the rooftop, even then it is excluded. Imagine, Act says, unless the completion certificate is granted, it will not be exempted. The rule says, if you had put up all the beams and the pillars, the first case which came across all over India was that of a very big company in Bombay, but filed at Madras, stated, we have constructed 14 floors. We have completed the beams and the rooftop. Therefore, we are exempted. Exemption also has been granted by the government. But he had not completed 12, 13, 14, all the 3 floors. Even the 12, 13, 14 floors, the roof was completed. One of the consumers brought to the notice that it's not a completed project, exemption granted is wrong. In any way of the matter, even in the completed portion up to the 10th floor, they have not handed over possession. So that gave me the opportunity. In the first case, in the case of 1 of 918, where we decided, because we have 3 members, the chairman consists of 2 and other 2 members. We could not, as a law, strike down the rule because we are not the High Court. We said, I used a simple word. A rule cannot override the Act. Simple. Rule cannot override the Act. Therefore, you come under the category. And this was also followed by the Bombay Tribunal The matter went to the Bombay High Court, and in Madras High Court they filed, but they did not pursue the matter. But in Bombay, the matter was taken up further, and the Bombay division went categorically held. Of course, there they made a small distinction. In Bombay, in certain flats, in certain societies, if you can, the inner portion is done by the purchaser. That is allowed. Therefore, in those societies where the agreement itself is only to construct this, because the inner portion is done by them, in that cases, it is allowed. In that, that rule will apply only to that portion. But whereas, as per the Madras judgment, when the act will not, the rule cannot prevail over the act, where there is no agreement to such an effect, when a constructed agreement is there, then automatically it has to be registered. So there is a division judge of the Madras, Bombay Court, almost in terms with the agreeing our judgment in the Madras. Why I am saying this is, the initial endeavor of all the builders was not to register. So they were under the impression, only if you come to RERA, an act will provide. Only when you come to the RERA, they will be part. The next defense immediately thereafter they took was arbitration clauses. In many of the builders, if you see, there is an arbitration clause, which empowers, they will say, arbitration prevail. Therefore, they will not come under the RERA Act. That's also, again, we settled. We said, it's a special act, therefore arbitration will not apply. Fortunately, the Madras High Court held, yes, the ruling was correct. It cannot be sent to, when there is a special act, overrides the agreement clause. This matter went up to Supreme Court. In MR MGF Law Limited, was Atap Singh, where special remedies are provided for and which are opted by an agreed person, that tribunal authority can refuse to relegate the parties to the arbitration. When there is a special provision, when he has come under the RERA Act, you cannot now say, we are go there to the arbitration. So now the matter is settled. The latest judgment is Supreme Court, where which it categorically says no arbitration clause can be taken into account. This is the latest development in regard to the implementation of the Act. Above all these things, under the Act, there are various provisions where it says both duties and responsibilities of the buyer as well as the seller. If the buyer does not pay the amount in tune with the agreement, he is liable to pay a penalty. At the same time, if he does not pay, and later on if he wants to get out, he is not eligible to pay get the compensation. Because the Act very clearly says the buyer can opt out to come out at any point of time. There is no dispute. At the same time, it also says if there is a fault on the promoter and the buyer, if he wants to come out, there is an extraordinary clause. Number one, he is entitled to get the full refund of the amount. Number two, he has got to get, now, as per 2.2% over and above the State Bank of India prescribed interest rate and compensation up to any amount as fixed by the court, then penalty and cost of this. All these 5 ingredients are there. Our people are really smart. He booked a flat in the year 2012, 2013 when the value was skyrocketing. Now in 2018, 2019, Corona, all those things, the price down has come down. Anyway, this fellow is not completed. If he wants to come out, he worked out. I paid 25 lakhs on that day. If now the present rate of the State Bank of India rate is 8.5. So add 2%, 10.5. Add 10.5% interest from 2014. This fellow gets for 25 lakhs, he gets more than 50 lakhs. Which is better? I would now opt to come out rather than to have the flat. Thereby, I get more money than buying a flat. So this sort of things increased. There we found out these are all not actual home buyers. These were the investors. In one particular case, we found out in that particular condominium, this one particular person has booked for 10 flats. Do you mean to say that he is buying a purchaser? Here is a person who has booked 10 flats. Now, conveniently, he is opted one flat because he says, I'm a buyer. I want to live to show under the pretext. For the 9 flats, now he asks for a refund. But conveniently, he has not paid the, after a certain amount, he has not completed, he has not paid. For the reason given by him is, he has not completed the construction, I have stopped the payment. So these are, in a way, there we held, no. If at all you are entitled to, you go back to your agreement. In the agreement, it says, this is a case, my outside, sorry. This is in the case of VGN Homes Private Limited versus Jairaj in appeal number 57 of 21, dated 22/11/2021, where we have, it's in the website, anybody can download it. Matter went on High Court. High Court has dismissed this appeal also summarily. There we have clearly stated. The builder is also entitled to terminate the contract. If the payment is not made, he is also entitled under the agreement to claim 24% interest. But the builder has not invoked. At the same time, he has agreed to receive the compensation, a lesser compensation. In those cases, even whether there is sale, the agreement will provide, he will get only rupees 4 rupees per square feet. Instead of 10.5% interest, as per the agreement, you are a defaulter, you are not an actual buyer, you are entitled to this. So this matter, we said no compensation, he need not be paid compensation. Penalty. He can be only able to retrieve this amount. So these are the new developments where it is not only the consideration which has been paid, when there is a default clause, you are also not entitled to get the result. This is the second aspect. The third important development, after some time, the builders, of course, they are very brainy. Now, you will say if it is less than 5 apartments or less than 500 square meters, then we will not come under this. They started building row houses. You would find in the advertisement a row houses, 48 row houses, individual houses. They were very clever. The individual agreement with every party, 48 agreements, 48 houses, and then the permit, 48 permits.
All less than 500.
All less than 500.
Not a flat. Not
a flat. Not a flat. Villas. 48 villas. But he forgot only one thing. Only point which I had was, there was no compound wall in between these houses. In all the plans, you would see there is a wall. But there is a compound wall. He had advertised gated community. The one advertisement, one brochure, which changed the whole case was, in the brochure, it says, you come to a gated community, and in between the houses, there was not a common wall. There is no, and there was only one. To save cost, he had only one, what he called as a common area, or what you call as the play area, all those things, amenities area. I said, for 48 houses, one common area, 48 houses, one compound wall, 48 houses, one STP, 48 houses, there is no other improvement in this. How do you call this as an individual house? And you say it's a gated community. Therefore, we said, even if it comes less than 500 square meters, or even if it is not 6 flats, once the condition is to get over this act will not prevail. They will come under registration, they will have to register, and this matter has also fortunately been upheld by the Madras High Court Division Bench. See the ingenuity in bringing a new development, but it took 3 years. In the meanwhile, they did not register.
Our own people will be there to advise them.
Rajendran, and whether the High Court will get jurisdiction over the RERA against the appeal, or any further appeal is provided there?
No, Act Section 71 is clear.
Further appeal to the High Court is
Further
there.
appeal to the High Court, which will be a division bench. Chandra Kumar judgment.
Oh,
So it's a division bench. So that is clear. Section itself said. Now, that's an interesting new act, new thing has come, which will come. Now there is no more work in the Appellate Tribunal. No, I have completed. When I retired on 31/3, the cases up to 21 was completed. 10 cases was only pending, out of which 3 because of the stay of the High Court, 7 only pending. And on 2022, after finishing some up to 31st March, only 12 cases were pending. So 22 cases were only pending on 31/3/22. Now that my friend has asked for, Ramshan has asked for this question, I'll come to that now. When you prefer an appeal under Section 71, you need to pay. The Act says Section 43, subclass 5. Section 43 is the Establishment Tribunal, subclass 5. Any person aggrieved by any direction or decision or order made by the authority or by an adjudication officer under this Act may prefer an appeal before the Appellate Tribunal having jurisdiction over the matter, provided where applicant files with the Appellate Tribunal, it should not be interrogated without the promoter. The word used is first having deposited with the Appellate Tribunal at least 30%. I leave it for a moment. Please listen carefully. I'm reading the section. Appellate Tribunal at least 30% of the penalty, or such higher percentage as may be determined by the Appellate Tribunal. So at 17, early 18, when we all met together in Allahabad, we had a Appellate Tribunal judges meeting to decide this matter. The word used here is at least 30% of the penalty, but there is a comma or such higher percentage as may be driven to the Appellate Tribunal. The normal interpretation would be 30% of the penalty or any other amount as per the amount. So I gave an explanation. Let's all work together. If it is a contested matter, 40% of the total amount, penalty as well as all the amounts deposited or directed to be paid should be deposited. And if it's an ex parte degree, it will be 30%. This throughout India, we have been following it. One person from Allahabad and one from Madras, he challenged this order. No, 40% is higher. I would pay only 30%. The Act says only 30%. You have to read the line without the comma. Say it should be only 30% of the penalty and 30% of the amount. Therefore, the discretion is not vested with the Appellate Tribunal. When you say you don't have power, normally we say, yes, we have the power. So we have decided 40%. When this matter went to the Madras High Court, Madras High Court said, no, The appellate tribunal has no power at all as far as all the amounts to be deposited. The penalty, the 30% will be restricted only to the penalty because there is a comma. The 30% stops the penalty and the rest of the amount, 100% has to be deposited.
No discretion for the appellate authority.
No discretion for the appellate tribunal. See the point? Allahabad High Court also said, yes, no High Court, no, matter went to Supreme Court. Supreme Court judgment is, this is the latest judgment. That's judgment dated 11/11/2021. New Tech Promoters and Developers Private Limited versus State of UP. They categorically said the discretion vested with the tribunal in only insofar as the penalty, and therefore an appellant has to deposit all the amount, though quoting the object which I read earlier on the both sides, but it is predominantly, since in the north the people are suffering, much payment of not paid, nobody is looking into that. Therefore, once he comes to an appeal, 100% has to be deposited.
Probably the Calcutta should have come to that mind.
Not they have taken
Home bias difficulty.
home bias difficulty.
Sarada,
But what
Sarada.
we were doing is, we used to collect 40% and give them 30%. Even at that time, interim orders. Now they are not getting it. Now, in 2022, for up to now, there's only 12 appeals. Nobody is preferring an appeal because the Act says the collection by way of EP has to be done under the Revenue Recovery Act. So it has to go to the collector. You know, everybody knows. Once it goes to there, it takes a longer time. Though under the Act, there is a provision that the appellate tribunal has got a discretion to levy costs 10 times the project value, and also to order for arrest. In one case, we did it. We ordered for arrest. Not even for not payment of money. It did not appear. At that stage itself, we ordered for arrest. You know what happened? Next day, he was brought to the court by the police. Commissioner asked the tribunal, sir, there is no warrant. How do we arrest? I said, the court order is a warrant. Therefore, you can arrest. I said, you are only directed to produce him to the court. We are not directing you to arrest. You produce him into the court. That's all. When he produced into court, the first thing he came along with was 50% check. See the difference. So, without even an order, only on the question of asking him to produce before the court, he voluntarily came with the court, sir, don't arrest me, give me 50%. 50% deposit. Thereafter, we proceeded and matter settled. Take another case. Even in the Land Revenue Act, the Chengalpattu area, which is the main area where for the Madras is concerned, one wonderful corrector, when he was called and it's explained about this problem, many numbers are pending. He took one initiative. We have directed that under the EP, he can seize or seal the premises. But he can only seal the premises of the building which is being constructed. You know what he did? He went and sealed the premises of the office. Entire 3-floor office. Made them get out, everybody, sealed. Next day, they preferred a writ petition before the High Court. Our collector has no power to seal. And that too, this is the property. But the division bench said, okay, he is wrongly sealed, but you pay the money and then we will open it. So pay 100%. And he paid even before this act came, before this ruling came. 100% was paid. Thereafter, it was over. The problem is implementation. Problem is implementation. But at the same time, because we are bound by the Supreme Court judgment, 100% payment is the only thing is hampering the appeals being preferred. Instead, they would prefer to go before the EP court, then thereafter the Revenue Recovery Act. They want to dodge, they want to delay. The immediate recovery of at least 40 to 50% of the money is being stopped because of the latest one. This matter also made another important relevant thing in the judgment. We all know if it is a tribunal, earlier judgments have said there cannot be a single member. Tribunal means at least 2 members should be there, and out of that, 1 judicial member should be there. Without that, no act can take place. Now, they made a distinction, of course. Tribunal is different from the authority because this is called Real Estate Regulation Authority. The Appellate Tribunal is called Real Estate Appellate Tribunal. In the very same judgment, in New Tech Promotions case, in the Allahabad High Court, what has happened is, there, the authority, there are also 3 members. Authority, there is a chairman and 2 members. One of the members sat alone and decided that matter. When the 2 other members were on leave, he said, I can decide it. Then they challenged that provision also, stating 1 member cannot sit. The very judgment is illegal. Fortunately, the Supreme Court stated no. Even a member can individually take this case. Individually can decide this matter. Therefore, on that ground also, they rejected this. And because of New Tech, what happened is, in everywhere, if there are 3 members, there can be 3 different hearings of the, because they want to, now they say there are 100 cases pending, so we will distribute.
Whether there is a quorum fixed in the act?
Luckily, quorum is not stated.
Because in our case, they said without an expert member, we cannot sit.
Because
there is no quorum is there.
No quorum is there. No quorum is there. But if you see the earlier judgment, the word definition given to tribunal is 2 members at least and 1 member judicial member. So that has given different connotation in this new judgment dated 11/11/21. It's a 3 judge bench. There they have stated no 1 member. Therefore, now all over India, we are now having different benches. Some 2 members, some 1 member, some 3 members, all this combination, permutation, combination. Is happening, will happen now. This is the second important development. Now, the third important development, as slightly passed out by Ravi Kumar, Justice Ravi Kumar. There was earlier a distinction. Under the Act, very clearly it states, if a person has gone already to the consumer court, he has to withdraw and can come here. There is no bar to coming here, but if he chooses to come here, he will have to withdraw.
Of election.
Now they said it is an election. He can come here, he can simultaneously go there. Not only that, as rightly pointed out, even he can go before the NCLT, stating that is a non. Beyond all these things, now they have stated the due by the promoter to the purchaser can come under a lawful debt as contemplated under the NCLT. So he can go there. So the choice is with him. He can choose among the 3 forums, wherever he wants to go. Now the question arises, whether he can go simultaneously. Now they are all going in simultaneously, that is still pending. That is again, another round has to go, whether simultaneously all the 3 processes can be done. The word used by the Supreme Court is that he has got the right to choose. But they are now choosing everywhere. That is another difficulty which we are facing. Of course, I think somewhere they are questioning, I'm not sure whether it is in Bombay or in Gujarat, where they are questioning it. The same thing, I'm not sure about it.
No, as far as NCLT is concerned, it is a winding a process. Suppose
Winding.
you are so
Company.
you are not deciding the right as a contractor or something like that there.
No, but point is, the arrears is claimed as the one for winding up. He finds, see, now I'll present a case. In fact, we have decided later.
Probably consumer and your court, maybe the services.
services.
It may overlap.
Imagine one set of people, many of the lawyers are here, okay, right. One set of people, our good friends, chose five people from the very same community. In one particular, there were 100 flats, let us assume. One particular group says 5 people go to NCLT, stating money is a claimable amount. 5 people come to RERA. 5 people. The problem is, this fellow says, now I have started reconstructing. You are not only stopping, if you are paying the money, I'm able to do it. There are certain cases who have left open, that's a different matter. What will happen to these kind of cases where such things are happening? Then we decided, no, we will appoint a committee. Committee means in the authority, we have a superintendent engineer who is also not only super, he was a chief engineer, PWD chief engineer, who is there as a committee member. So we appoint a committee to go there, inspect, and also ask them to follow it up. Because under the section 8, we have a power. If he's not constructing, it can be stopped, taken over by us, given to somebody to construct. No, we did not take up the construction. We asked them to have a supervisory control, whether he is at all constructing. Remarkably, he was constructing. That period has been delayed. Then only we found out, now you understand, one particular group going here, one public coming here, browbeating. That cannot happen. At the same time, for the delay, yes, you have to pay as per the agreement. Continue to pay. At the same time, you need not stop the payment, the purchaser. As long as you pay, he can construct. So the act is a via media for both. There are compulsions, there are utilization, we can do on both sides. Unless it is agreed, unless it is done in that way, we can't proceed further. This is one of the latest developments in the RERA, insofar as to the different area of it. Now comes the very latest 2020-22 judgment. After 2021, 22. Just 1 minute, just give me 1 minute. Yeah, this is the judgment. Union Bank of India versus Rajasthan Real Estate Regulatory Authority. Judgment date is 14/2/2022. Allow me to read paragraph 36, which has been extracted in this of the lower court order. They have summarily rejected the appeal, recording that the lower court authority has done correctly. There they have extracted this order. Our conclusions can thus be summarized as under Regulation 9 of the Regulation Act of 2017 is not virus, ultra virus, or is otherwise not valid, because they questioned that the power. Again, the delegation of single member. The delegation of powers in the single member of RERA to decide complaints filed under the Act, even otherwise follows from Section 81 of the Act, and such delegation can be made in the absence of Regulation 9 also. Therefore, even single member can say subsequent also has come. As held by the Supreme Court in the case of Vikram Chatterjee, in the event of a conflict between RERA and SARFAESI, in the event of a conflict between RERA and SARFAESI Act, the provisions contained in RERA would prevail. This is the latest judgment. So, in between RERA and SARFAESI,
Probably
even if it
RERA is the later one, and also in suspect special act.
special,
Probably.
they are-
Dealing
they are-
especially with
same thing, following the earlier act. MRMGF. But now, I'll just go through on the 2 more sentences and then we'll come back. Clause 4. RERA would not apply in relation to the transaction between the borrower and the banks and financial institution in cases where security interest has been created by mortgaging the property. Now, this is important. Prior to the introduction of the Act, unless and until it is found that the creation of such mortgage or such transaction is fraudulent or collusion. Therefore, they get one safeguard. If it is created prior to the Act, it will not provide. RERA authority has the jurisdiction to entertain a complaint by an aggrieved person against the bank as a secured creditor if the bank takes recourse to any of the provisions contained in section 13(4) of the SARFAESI Act. So now, even if his action is taken under section 13(4) of the SARFAESI Act, if the agreement is after 2016, then a buyer whose money has not been paid can go to the RERA and stop the order of 13(4). So 13(4), we are now one step ahead. RERA will become a superintending authority in regard to the 13(4) Act. This is the present latest judgment. Therefore, now RERA has superseded Consumer Court Act. RERA has superseded NCLT. RERA has superseded arbitration. Now RERA has SARFAESI Act. All these things will now come under before RERA. And RERA money paid will be a debt within the meaning of NCLT.
So there is a quantified area with the amount.
Quantify the amount. So they have given more powers to RERA so that people can get the benefit out of the RERA. The only point at later point of time is in the appellate stage, yes, you are bound to pay 100%. So that is also curtailing the totally amount has to be paid is the present position of RERA. And one more thing. This is also one of our case. They used to bring orders from because the Act says a completion certificate, if it is given, then they will be exempted under RERA. So people thought that in Madras, I mean Tamil Nadu, this may be applicable only in Tamil Nadu. Some other states, I'm not aware about the rules there. Only in the notified areas, completion certificate is given, actually in CMDA, what we call as a city metropolitan area or in corporation area. In other areas, earlier it was used to be a Town Planning Act, under the Town Planning Act. There was no completion certificate. So they thought, very good, ingenious people. All these places where it is in the Town Planning Act, they took a certificate from the then executive officer or the Panchayat president that there is a completion. Though it is not required under law to get it, they got it and filed it before the authorities and even got exemptions. In one of the case, that's in appeal number 7 of 2019, earliest appeals, Pacifica Chennai Project Infrastructure Private Limited versus C.R. Sendil Kumaran and C. Dhanalakshmi. This order was confirmed by the Madras High Court Division Bench in CMSA number 31 of 2020, dated 2/12/2020. There the High Court was also held. The tribunal took note of the entire factual details and clearly called out as to how the president of the village Panchayat, Pudupakkam, issued a false certificate without following the mandatory procedures under the Act. This will clearly demonstrate that the appellants were somehow trying to manage to get out the rigor of the statutory provisions. Thus, we find there are absolutely no ground to interfere with the order passed. Therefore, such certificate issued by any of the village officers or the panchayat president or the executive officer cannot be a ground to seek exemption under the Act, and this has been upheld by the Madras High Court, coupled with the fact Adinath, in another case, appeal number 5 of 2018. Adinath Srinivasa Foundation, LLP versus the Secretary, Serene Kshetra Owners Association. The net result is there. When the builder has not completed the project as per the approval, either on the date of the coming into force of the Act, and even as per the report by the authority concerned, as per the direction of the Real Estate Regulation Authority, much after coming into the force of the Act, they have completed the project at all. Therefore, rightly, the authority has come to a conclusion that the project needs to be registered. Projects that are ongoing on the date of commencement of this Act and for which completion certificate has not been issued, the promoter shall make an application for the authority for registration. So after this, we have got number of registration. Now, registration, we don't have any problem at all. Everybody comes to registration because we have now made one more step. Even though they register, because the Act says you will not even get an advance amount, and that too at least only less than 10%. Before registration. You cannot get a advance amount before registration, even though you might have got the plan approval, everything. To circumvent this, they used to get the agreements later date. Now we said no. The agreements, once anybody who have not registered, and if any collects the money, we have given penalty. Penalty in one case, we have given a penalty of 10 lakhs. Because he repeatedly done in the second project also. So penalty plays a vital role in so far as to the registration is concerned. Next important aspect, which is also now clearly done by, they wanted to say whether a landowner who gets a share in the property, whether he can be called as a builder, whether the purchaser can sue both of them. The landowner took a stand. I am also a allottee. I am not a builder. Though he gets 6 flats out of the 18 flats, the initial brochure conveniently says, in the project, both of them are together. Suppose if he is able to establish that instead of the consideration for the land, what he gets only is the flat, and he is no way responsible for the construction, then he is exempted. In other words, the inclusion of both of them in the capacity of the builder will arise only so long as he participates in the building activity. Here, in this case, particular case, he was not only propagating himself as a builder, he brings people, he collects people. What has happened is, out of the 6 flats sold or allotted to him, he sells 3 plots or 3 flats. So to them also, he becomes a builder. In that way, he is not only a landowner, he is not only an allottee, he is also a builder. He comes into 3 different aspects. Therefore, he cannot wriggle him out of himself, and he may at least say, I'm also a person who is affected because my 6 flats has not been allotted. Now, at least the 3 flats which he has sold, it has to be completed first. He is answerable to that. To that extent, we have also held that in the capacity may differ, his name may differ, but he will also come under this category. This is the latest developments. Now, interesting question. One interesting question arose. What do you mean by an apartment? Apartment could only mean a person who is able to live in that, who are able to be reasonably live in this property. Now, another question, in the same case, there are two different towers. But the main ingredient of the brochure was you will be able to go along the flats, if we go along the very property, go along the towers together. But if the towers are not connected, if the cover, though it is stayed interlinked, if it is not done, whether it will amount to non-completion, whether it will amount to an ongoing project, whether it can be registered. Yes, we held that any incompletion of any part of the construction as agreed to be in the brochure, as agreed to between the parties, even though it may be a smaller one, but if it is not done, say for a clubhouse, say for the amenities, say even for the interlinking of the state, then it will not amount, it will amount to an incomplete one, which has also been upheld with the Madras report. Lastly, I will only quote a recent judgment of our tribunal. A flat purchaser buys a property. It is a corner property. It runs near the common pathway. What he does is, beyond his house, there is no other house. Therefore, he has obstructed the common pathway, put up his own construction. But there is an interlinking of the other side which can come here. His only argument was, it was a common, even though it was a common pathway, nobody can use without my permission. Yeah, I've just closed it. And what we found out was, for granting this permission to put up this construction, the builder has received extra money. But builder conveniently, when it came to RERA, he said, I'm refunding that 7 lakhs of rupees. He has refunded at 7 lakhs rupees. This fellow got the 7 lakhs rupees also, but not removed it. When the association challenged this, we said no, it has to be demolished, and it has to be a pathway or a common area cannot be taken into account by any individual flat owner. And ultimately, it's the first case where RERA was able to demolish that portion. So far, we are not able to, we did demolish that portion, and that has also been done. So these are the latest developments. Because every day it's a developing law, it's a new law, it is an interesting law. It's a question where it is coming into the betterment of both the parties. Anyway, it has been doing a very good job. In all over India, RERA is doing a very good job. In, of course, in Bombay, in Haryana, and in Punjab, the mind-blogging numbers have come. And I heard in Haryana and Punjab, 28,000 cases have been filed. Imagine. Of course, there are lakhs and lakhs of flats are pending, and therefore there's not numbers have also risen to a large number now. Of course, in South, we do not find that might of day, excepting in Bangalore, a little bit more in there. Here we have done very good, and the registration is now good. So people are knowing about it, and without registering. And last, we have also given in Tamil Nadu. We should have circular to the registration department. If anybody comes to register in respect of even a plot, what they used to do is, the plots are what you call unapproved. Even unapproved layout, if it is not registered with RERA, therefore they can't do it. But on entire things have stopped. Now unapproved plots are coming for registration after getting approval. So this is one thing in Tamil Nadu we have done. So we are getting all the unapproved plots to be becoming as an approved plot after registration with the concerned authority, and thereafter we register. Only then they can register. The circular has been issued all over the state, and the registration department has stopped the registration, and there is an influx of number of cases of registration. And that takes us 1 hour. I think I've done that. Any questions, I'll be there. Thank you once again for the wonderful opportunity of meeting you all, first of all, and also and participate in the 275th meeting. Thanks, one and all.
Thank you very much, sir. It is indeed wonderful to have you back, and we would like to make a request that be here with us in the forthcoming sessions. Also, we would like to have your thoughts and inputs in the different sessions that we have.
Sure, definitely, sir. Definitely, sir. Now that I'm free, I can join.
Thank you, sir. We live in a country wherein we don't have any paucity or scarcity of laws, or maybe it is we need some sort of family planning for laws. I mean, too many laws. But so there are certain occasions and circumstances when it is not the law, but the person who is put in charge, or the persons who are put in charge of implementing the law, makes the whole world of difference. Like how you perceive it, in what background, the mischief which the law intended to curb. Once we understand and assimilate that, and the persons in the helm of affairs are proactively approaching instead of a mechanical application of what the act is, I think wonders like this can happen, and there are different interpretations and the way in which things could be straightened out instead of going it up and down. And absolutely, sir. So, sir, in this background, may I just request Justice Ramkumar sir's views on the topic.
Thank you, Shyam. Excellent and systematic articulation of the subject with most practical issues being highlighted. Now, as rightly said, what we want is TN sessions. The election commission was unknown entity till session occupied the chair. Likewise, we want sessions in every chair.
Yeah.
And can the authority look into inter-se dispute between flat owners?
No. Inter-se dispute between flat owners, we will not engage, because that's not correct. If he is a, see, strictly speaking, your question, the last case, a flat owner says the common area was obstructed.
Yes.
That is indirectly a flat, it was between the next flat owner. But he was very clever. He did not individually come, he came through the association. But the builder, he repaid the money. So builder said, my hands are free. But I said, no, you colluded with him. You have given this area, allowed him to construct. In fact, the builder only constructed that. That's why indirectly he can do it. But directly, no, it cannot be done. It's not. Because Act never provides. Never provides.
Is there any law which compels the flat owners to form a society?
Yes.
Yes,
Every
Apartment
state,
Act.
Apartments Act. Apartments Act.
Okay.
That says you must have an.
Because I find in many buildings, the flat owners, there is a regular fight between the flat owners on the common area, on the payment for common area, common facilities, etc. They go on fighting, and water, electricity, gas.
They don't. In one of the particular case, they brought to us notice, there are about 60 people living in that flat. 30 people are the occupants or the owners. 10 of them are tenants. Rest 20 is unoccupied. Rest 20 is
maybe mere investors residing in Gulf or somebody.
They are all NRIs.
NRIs.
They are not bothered about it. Exactly. They have not paid in the same charges for the past 5 years. They tried disconnecting the electricity. What use? No problem for them. He said, you sell this property, I'll pay you. So literally 40 people is paying for the consolidated charges with the 60%. This is happening. This is happening. The only provision open to them is to cut off electricity and water, for which he also is not bothered. He is there outside.
Exactly. So their remedy lies before the which forum?
Civil court. Attach the property again. You attach, you sell and give me.
Thank you, brother. Thank you. Wonderful.
Thank you so much, sir. Thank you, sir.
Thank you, Justice Ramkumar, sir. May I now request Justice Ramakrishnan, sir?
It's a real estate is a real problem always. Because there are ingenious people want to avoid so many things,
Obviously.
even getting environment clearance or even getting the approvals, layout. Say, I think that you said that layout approval, in
Yes.
as far as Madras and the Town Planning Act is available, without the approved layout, can they go for flat construction?
He can't.
You can't.
No, but what they do is they sell as a plot. Without the
Individual
approval, they
plots.
sell as an individual plot. The fellows buy and ultimately they find into trouble. So that is why we said we'll bring it to RERA. Though I know we brought it into this.
No, anyhow, it's a no. It
Oh,
is
you
an area.
understood.
No, it is an it is an area where it is always a new things will come up, and for the purpose of protecting both the promoter as well as the consumer, something will have to be done. I mean, within the limits of the provisions that is required. So anyhow, it's a eye opener to everyone to know about the intricacies of the provisions of RERA, who are entitled, and also remove the doubt as to whether it is only for the benefit of the consumer or detriment to the real estater.
Yes.
The other thing, as rightly said, deposit of money is a condition, because I got my own doubt about that. See, if you say a discretion has been given, can it be said it is a condition present for entertaining appeal? Unless you deposit, you can't do it.
You can't do it.
So, if that be the case, if a discretion has been given, you can file an appeal without deposit. It is for you to decide what amount you will have to deposit. Can it be said it is a condition precedent then? It is maybe a ground for granting stay, admitting it.
Now, how we took it was, if you see the Income Tax Act, original Income Tax Act, if you have to prefer the second appeal, then you have to deposit 100%. That is the act. We entertained in the High Court, in the division bench, granting them 30%, 40%, 50%.
That is because of your precatory power.
Here there was a magic word, catchword, appeal pending, my lord. Appeal pending. That was the magic word for lawyers.
I took that particular passage way back in 1983. The Madras High Court division bench has stated, no, they use the same word. Though the condition precedent is to deposit, but the court has got the discretion in exceptional cases, where at least 40%, 50% money is coming. Otherwise, no money will come.
That is the reason why people, without going to the appellate authority, they will come to the High Court under 226, say then natural violation, natural justice violation, no audio alterum bottom is not there, and then get it admitted and then go without paying any amount, and then get a remand for free consideration with the assessing authority.
Less onerous remedy.
Anyhow, it's a new area where people are getting enlightened on account of your personal experience on the subject, and also as a person deciding factor, a regulating authority. Really, it's an interesting and experience which we are also enjoyed along with you in this thing. Thank you very much. I may be going because I will want to go to the doctor for a regular consultation. Nothing this thing. I got the appointment. Okay.
Everything functioning okay.
Everything functioning okay. To get it certified.
Okay.
Okay.
Right.
Thank you.
Thank you so much, brother.
Thank you.
Thank you, Ramashan sir. We have the faculty of the last session, Harikumar sir. Sir, over to you.
Thank you for inviting me. I could not hear the whole thing. I could enter only with the last words of the honorable judge.
Oh.
But I'm happy to enter into an area which is totally alien to me. May I ask you, sir?
Yeah.
A doubt. Can anything be entertained by the RERA for a project which is totally finished prior to the coming into force of the act?
You have a beautiful question. Sorry, I didn't mention about this. Section 14 comes to your rescue. See, Section 14 says, even if a project is completed within 5 years from the date of completion, if there is a structural difficulty or any other disform, they can bring to the notice of RERA and RERA can rectify it. Therefore, Act came in 2017. So up to 5 years. Or if the project is completed,
2012 also can come.
up to 12 also can come. Again, we have decided on that. But you'll have to bring in as to say it's a structural wrong. Use that word. Section 14 uses that word. So use that word.
Latent defects became patent now only.
Pardon?
Latent defects became patent now only. We are obvious now only. We can also say that.
Defective service.
Out of inquisitiveness, may I ask one more question?
Yeah, please.
Supposing the allottee, after completion of the project, receiving the villa or the apartment as the case be, makes an acknowledgement with wholehearted thanks for finishing of the project within the minimum possible time, etc., etc. And then he approaches after 3 or 4 years before RERA.
For
See,
what?
this is a
For what?
hypothetical question.
No, for what? The question is
Saying
for
that
what?
some facility offered was later on found to be.
Fantastic. Fantastic question again. There is an answer.
Hidden.
No, there is a wonderful question. Because we found in one case, he had promised a swimming pool. He has completed, constructed, granted, and he had also one certificate. Among some people, they have given a letter to him stating how many people are using the swimming pool. Don't waste money on the swimming pool. You put up a garden. These are all persons whom he has chosen. They have given a letter. He has kept it in the file. Completed, handed over, gone. Signature. They came to the High Court. I mean, here, RERA. We said, you had promised this to do in the brochure. You are bound to do it unless 2/3 of the members, because Act says any difference in opinion or any change can be made only by the 2/3 of the majority of the people. Therefore, he had not got the 2/3 majority in his hands. Then we said, either you do the swimming pool, but as rightly pointed out, many of the people may not want swimming pool. But to that extent, either you deduct the money or give another amenity equivalent to that money. So that also can come. But all these things within the 5-year period. The 5-year plan, if you lose, then you lose. Because 14 is there. 14 is there. We utilize that.
Definitely. So one thing I think I had not made clear by the very same person who has acknowledged satisfaction.
Yeah,
complained by the very same person.
No, everybody has acknowledged. No, everybody has received the flat without any demur. One of them is coming again.
Yes.
See, only. See, every out of the 60 or 70 people, only some people have not given letter like. Others have taken the flat without any demur. They have only stated this. They have come to court. There's nothing wrong.
No. It's not a case like that, sir. What I said is only one allottee among 100 allottees come before your lordship, and then makes a claim after having himself acknowledged 5 years prior.
I understand. Even one member can bring to notice, nothing wrong. It need not be the association. It need not be a number of members, number one. Number two, even if he is acknowledged, but if he is able to prove before the court, a promise which has been made, either in the brochure or in the agreement, which has not been completed or not properly completed, can still come to RERA if it is within 5 years.
So
I understand, sir. I understand, sir.
His earlier appreciation will not stop him.
Stop it.
So that is decree satisfied can never be treated as satisfied.
Never been satisfied.
Because I told you, sir, I'm totally alien to this area.
Okay.
And out of curiosity only, sir, I just entered and when I entered, I found two very important academicians are sitting there, especially Ramkumar sir is sitting there, and he was giving all praise for your endeavor. Then I thought of asking a question. I may be excused if my
Not at all.
question
Not
goes
at all.
beyond.
Not
Then
at all.
I have a feeling from some orders that have come after RERA appeal for challenge before the Honorable High Court of Kerala, that is from Kerala, that the general trend is, I'm only quoting a Purana thing, that is, if Kijaka is found dead, no doubt, RERA will determine without entering into any other search, any other inquiry, that it is none other than Bhima.
Let's see. Let's
See,
see.
it's only my impression of what all I have received to challenge, only few, say maximum 4.
Maybe there are no stations.
Let's see.
Sir, now, thank you very much, sir. Now coming to the builders side, we have Mr. James here. James,
Yeah, please.
let to unmute.
Yeah. In fact, I have 3 questions. The first question is, so we have a joint agreement, JD agreement with the landowner, and we have started the construction. And later,
Before
the
that,
land is
it a
registered
pending-
in favor of the builder.
1 minute. Is it a pending case? Don't discuss a pending case in the meeting.
No, it's not a pending case.
That's all.
No, it's not a pending case.
Okay.
And later, the land is registered in favor of the builder.
Okay.
All the flats were allotted, after the JD agreement, all the flats were allotted to the landowners. Now, after the registration of the land in favor of the builder, will the landowner remain as a co-promoter?
That's what I answered earlier. He may be a co-promoter, he may be a lottee, he may himself be the person who is getting some of the flats. But if in the brochure he says I'm a co-promoter, if he says or makes them to understand that he's also dealing with that, or if he's in any way connected with the construction, he will be called as a co-promoter. If his angle is one,
He's not at all connected with the construction.
then he will not be called as a co-promoter.
Okay.
Like his role was only in the joint venture agreement. After that,
That's
there was no reference of the landowner.
Then he is not a co-promoter. He will be called as only as a landowner.
Okay. Now my
Yeah.
second question: if a person loses case from a consumer court, can he still approach RERA?
That is not permitted because section says he has to withdraw the case and come. Supreme Court says he can choose any place. But if you lose there, you can't come here.
Election.
Election. You are already elected.
Okay. Now my third question: say we get a building permit with the Fire Force Department approvals and Pollution Control Board approvals, and during the period of construction, the Pollution Control Board or the Fire Force Department change their norms, and they are somehow requirements in the the provisions to be made, but the building is constructed as per the licenses obtained. Now, if the allottees ask for the provisions as per the latest provisions of the concerned departments, are we supposed to provide that?
Because you are bound by the subsequent act to the department where you have been served with the notice, you have been directed to do something, you have not completed. Tomorrow it will develop upon the purchaser. Therefore, he is entitled to ask you that question.
No, it has not been asked by the department. It's a subsequent amendment made in the rules. But before this amendment, the building permit was already approved and the construction took place as per the permit we got.
Then it's a question of interpretation, how the department is going to take. As long as the department did not give you any notice, did not ask you to change, you need not change. You need not change because Your planning permit is prior to the amendment. You have also started construction. Therefore, that will not contain.
Okay. Thank you.
Thank you.
Thank you, James. Dilip sir, you'll have to unmute.
Good evening, everyone. As Harikumar sir said, I am also not proficient or has not laid my hands on this statute, and I don't know anything about it. I wanted to hear and get enlightened.
Okay.
So thank you very much, sir.
Thank you, sir.
One doubt that has been there in the chat box is regarding few of the apartment owners not contributing to the or participating in the activities, in the sense like they are not paying the maintenance fee and things like that. So the doubt expressed is according to the query is there is some court decisions which says that you cannot take law into your own hands, like you cannot cut the common amenities, you cannot do. Then is it true that we can only sue them for recovery of money and let them use all the amenities? The persons who are the chronic defaulters.
A chronic default, this has happened, but every high court has said you cannot disconnect the electricity. But at the same time, in Madras High Court, it has said, no, you are bound to pay 50%. There is a conditional order. But they say you will pay 3 months later. But today itself, you open the electricity. That is it. Because that the association is not vetted with the right to disconnect. That was said in the High Court. But they directed them to pay after 3 months. But even after 3 months, they don't pay. They don't pay. That is a difficulty. But I answered, Ravikumar asked that question. 60 people in a house, 30 people only pay. Others are NRI, they are not paying.
Correct, sir. So a natural corollary of that question also has come up. That is, if the association says that we are ready to waive, we don't have any problem with you not providing with certain common amenities which you had promised in the brochure. But whereas 1 or 2 individual apartment owners are not agreeable to that, but they are outvoted in the association. So what is the remedy, or they should go remediless?
They can only go to civil court. This is only to civil court, but not nobody else. This will not come under RERA. This will not come under anything else.
Okay, sir. I think KVJ Rao sir is unable to. I mean, he's here. Rao sir, you got any comments to make? Yes, put the hand icon up, but so, sir, I would say it has been a wonderful evening. It is our 275th session, and we could not have asked for anything more. Such articulation, such clarity, and I'm sure that the very fact that the number of questions are not either in the chat box or from the participants is an indication that the way in which you presented, the way in which the recent developments have been highlighted was really, really very clear, in the sense like everybody has got a clear picture of that, and we have got a super body coming up, the RERA, who has become just like the giant who is consuming all other acts and things like that. Absolutely, sir. It has been a wonderful experience, and let me, on behalf of this platform, thank you again for taking time out and sharing your wisdom on this specific specialized topic. Thank you very much, Justice Rajendran, sir. And
I thank all of you, especially you and Justice Ravikumar and Ramkrishnan for having participated. And congrats and kudos to you. Keep it up. Do it very well. All the best.
Thank you very much, sir. We are privileged and we are thankful to Justice Ramkumar, sir, Justice Ramakrishnan, sir, Harikumar, sir, and James, of course, and all those persons who proactively participated, offered the comments, and enriched this evening. Thank you very much. Till we meet again next week. Please do take care and stay safe.
Thank you. Thank you.